Hello, I'm Payal Chawla and welcome to my podcast Navigating Commercial Disputes, brought to you in partnership with Bar and Bench. In this podcast, I aim to break down complex commercial legal issues for lawyers, law students, and legal enthusiasts alike. At the heart of most commercial disputes lies the issue of damages, which can broadly be categorized as liquidated and unliquidated. Liquidated damages refers to a pre-estimated sum specified within a contract payable to the aggrieved party in the event of a breach. The purpose of a liquidated damages clause is to provide certainty and facilitate dispute resolutions by ensuring that the breaching party pays the sum agreed upon. However, while the concept may appear straightforward, its practical enforcement can be far more complex, particularly if the contract or pleadings lack the requisite elements. Under Section 74 of the Indian Contract Act 1872, liquidated damages are enforceable, but only if the specified amount is a genuine pre-estimate of the loss suffered by the aggrieved party. Poorly drafted clauses or pleadings regarding damages can be more detrimental than beneficial, as they may require the aggrieved party to prove the actual loss, and the specified sum could act as a cap on recoverable damages. To bridge the gap between the theoretical and practical aspects of liquidated damages, I have with me today a highly accomplished lawyer, senior advocate, Mr. Gaurav Pachnanda. Gaurav has a wide-ranging practice in commercial litigation and arbitration across multiple jurisdictions. In addition to being a senior advocate in India, he is also a barrister at Fountain Court Chambers, London and Singapore. He has extensive experience as both counsel and arbitrator in various arbitration proceedings, including those governed by international arbitration rules such as SIAC, ICC, LCIA and UNCITRAL. Gaurav has co-authored the authoritative book on damages, expert evidence and valuation in commercial disputes in India. Welcome to the show, Gaurav. I'm so delighted to have you on the show.
Thank you very much for having me, Payal.
Gaurav, before I really get into the complexities of liquidated damages, I thought we'd kind of slowly veer into it. Explain what are liquidated damages?
In order to understand what liquidated damages are, I think a better way to start would be to explain what unliquidated damages are.
Right.
So, in a case of breach of a contract, there is no limit ordinarily to what parties can claim as damages, as long as they fall within the legally permissible paradigm of what you can claim, a direct loss that arises as a result of the breach. Liquidated damages is an expression that is used to explain a situation where parties have themselves estimated and contractually agreed to damages that would be paid in the event of specified breaches. So in that sense, liquidated damages are pre-calculated damages and liquidated by a fixed number.
So would it be correct to say that the contract would specify a certain amount as damages and that would be liquidated, and where a contract doesn't specify, that would be unliquidated damages?
In the manner in which Indian law has developed, Payal, it would be correct to say that the concept of liquidated damages would be equally applicable to a situation where a contract has provided a formula or a methodology of calculation of damages in a particular manner. So in present day construction contracts, you would often see that certain parameters are predefined, and then for every day of delay, for example, those will be multiplied. So if the delay is 10 days, the parameters will be multiplied by 10 times. If it is 11 days, multiplied 11 times, and that is the manner in which liquidated damages will be payable. So in some sense, there are formulae that are applicable in contracts where the number or the exact amount of liquidated damages might depend on either the severity of the breach or the number of breaches. But broadly speaking, the manner in which contract law is developed, a lot of those provisions would also qualify as liquidated.
And would you say that that's the preferred method versus just putting a quantum?
Increasingly, in modern complex contracts, there would be either a methodology of calculation of liquidated damages or a blend of both, because there might be a simpler breach for which only a liquidated damage number is provided, but there might be breaches of more complex character for which a formula or a methodology is provided.
And do you think that it is better to involve experts at the stage of drafting? Because experts are used typically at the time when the dispute's already begun. And would it, kind of help bridge the gap between the errors that occur at the time of drafting if they had experts to help them?
You mean in the context of liquidated damages clauses?
Yes.
In the context of liquidated damages clauses in Indian law, there is a concept of it is not sufficient to say that this is a liquidated damages provision that parties have agreed to. It's a at least three-layered sort of test that is applied. And I think in the context of that three-layered test, it might make some sense to have some degree of pre-estimation done at the stage at which parties are agreeing to a liquidated damages provision. It might be helpful when a matter goes to trial to demonstrate that this is a genuine pre-estimate that the parties contemporaneously assessed. But to be very honest, there is no judicial precedent based upon which one can say that it is a preferred method. But I think that it would definitely advance the cause of a liquidated damages provision if some kind of analysis or pre-estimation exercise has been done at the time of entering into a contract.
Now, you mentioned pre-estimate. That is a requisite of liquidated damages, isn't it?
My understanding of the manner in which Indian law looks at liquidated damages provisions, it would be like this. So the first prerequisite is that there should be loss.
Yes.
So if the breach has resulted in no loss, it would not entitle a party to claim liquidated damages. This is not a requirement that comes out of Section 74 of the Contract Act per se, but this is a requirement that comes out of very strong shadows of Section 73 of the Contract Act that have been imported on Section 74 by judicial precedent or by an interpretational exercise. So first test, that there should be loss, and liquidated damages provisions would not assist a party making a claim that has suffered no loss. The second layer would be that in almost all cases where it is possible to prove loss, Indian law will require the party claiming damages to prove the quantum of its loss, which will be reasonable compensation for that breach. And the quantum of that loss will be capped at the liquidated damages amount. And this broad principle will make no distinction between a penalty or an amount treated as a penalty or designated as a penalty and a liquidated damages provision. So if it is possible to prove loss, irrespective of how you've designated a liquidated amount, what you will get will be what you prove as reasonable compensation, applying the tests of Section 73 and subject to a cap of the liquidated amount. And the third situation will be that where it is impossible to prove loss. The expression difficult is also used, but in my own view, it is really impossibility or difficulty of the nature of an impossibility. So where it is impossible to prove loss, there of course a party will be able to make a claim for the liquidated amount, provided it is demonstrated that it is a genuine pre-estimate. Or the other party, the party that is opposing a claim, provided that party is not successful in demonstrating that it is not a genuine pre-estimate, it is hugely disproportionate. So these are the three layers on which a claim for liquidated damages will be tested under Indian law.
So that would be loss, it would be that it's a genuine pre-estimate, and
first would be that there is loss. Second would be it is possible to prove loss. And if it is possible to prove loss, that the amount claimed is reasonable and it will not exceed the liquidated damages amount.
So the liquidated damages amount becomes the cap.
Yeah.
And what about the fact that if it's a genuine pre-estimate, can it be a penalty or can't it be a penalty?
So I think Indian law does not really regard any distinction between a penalty and a liquidated damages amount. If you look at construction design, the decision of the Supreme Court, it's a classic case of treating a penalty and a liquidated damages amount as interchangeable expressions, which is correct. Under 74, it would not matter whether you've designated it as a penalty or whether you've designated it as a liquidated damages amount. In both cases, if it is possible to prove loss, you will only get what you are able to prove as your actual loss, and it will not exceed the capped amount. So if you prove the entire amount or more than the entire amount also, you will only get what you have liquidated and agreed.
Right.
It is only when it is impossible to prove loss and you are now in an area, the third layer, in an area where you are almost telling a court or a tribunal that there is no choice but to give me a liquidated amount agreed between the parties. It is only in that area that you will end up then testing whether this amount is a genuine pre-estimate or not. And what is not a genuine pre-estimate, or what is without any basis, or what appears to be penal, may be expressions or principles that may then be applicable in the third layer.
I see, that's very interesting. So what you're basically saying is that at the first level, the court has to determine that is this an impossibility? And if it's an impossibility, then you get into whether this is a genuine pre-estimate or not. And then the expressions liquidated damages and penalty sort of tend to merge. And
if it is not a genuine pre-estimate, then you wouldn't get the amount irrespective of whether you designate it as a penalty or a liquidated damages provision. And if it is a penalty, but yet you are able to demonstrate that it was a genuine pre-estimate and not really meant to be disproportionately deterrent, you might still get it. And that is what construction design eventually said.
So it seems to me a bit counterintuitive in that sense, because at one level, we look at reducing the burden from the courts. And you do have the provision of 74, and it's very interesting that what you've said, and I agree that these are jurisprudential principles evolved by courts that have been kind of read into 74. Do you think there is scope to read 74 as is? Of course, putting a duty upon the parties to come up with a genuine pre-estimate and then not be treated as a cap?
If you look at the wealth of Indian cases in jurisprudence on liquidated damages clauses, there are very few and almost negligible where a claim for liquidated damages has been rejected on the basis that a party was entitled only to prove reasonable compensation and has not proved it. In most of the cases, we discover that even though in another country, a breach of that nature and a loss of that nature would have been capable of quantification. There is a trend in Indian jurisprudence to sort of classify them as complicated cases where it is nearly impossible to prove loss.
Right.
And then lean in favor of awarding the liquidated damages amount, provided it does not shock the conscience of the court as being disproportionate. So in reality, I think courts still make an attempt to avoid situations where actual loss and actual quantification of loss is required to be proved. And still the majority of cases are cases where either no loss was proved and the entire claim was rejected, or the court felt that it was fairly reasonable to presume that this is a complicated case and the entire liquidated damages amount can be awarded. In one or two cases, a part of the liquidated damages amount was awarded because the court intuitively felt, not based on any calculational
Right.
exercise, but intuitively felt that, let's say, liquidated damages was X, but perhaps 2/3 of X is a more reasonable amount, and applied a broad brush formula and awarded that amount as reasonable compensation.
You've co-authored a brilliant article on burden of proof and damages. So, talk a little bit about burden of proof in the context of liquidated damages, and is it different for unliquidated damages, and what's the position under evidence law?
Broadly, on first principles, if you say that a liquidated damages provision will work in a manner that is broadly similar to a unliquidated damages situation, and in those cases where it is possible for you to prove your loss, you will prove reasonable compensation that you should be given for the purpose of that loss. Then, broadly speaking, the principles of evidentiary burden and the rules of evidence that will apply obviously will be similar.
Right, so the party that has suffered the loss or alleging the loss is the party, the burden of proof will initially be on that party, right?
Yeah, so let us talk about all the three layers. First layer, whether any loss has occurred, whether you suffered a loss or damage.
Right.
The party that makes a claim for liquidated damages will have to prove it. And the party that contests that position will, once I've discharged my burden, the onus will shift and the defendant will then prove whether I have not suffered any loss,
right,
according to that defendant.
Right.
Layer 2, where it is possible to prove loss and I have attempted to quantify the loss. The obligation is on me, the person who's claiming the amount, and the obligation is then, the onus shifts on the defendant to then show that my quantification of loss is either unreasonable,
right,
so the unreasonableness will have to be demonstrated by the defendant, or that my quantification is incorrect or incapable of reliance for some other reason, principles of award of damages, calculation of damages. In the third situation, and this is an area where it is there is a little bit of sort of lack of clarity on how the burden of proof should work. In a situation where it is impossible to prove loss and a claimant says that it will be entitled to the entire liquidated damages amount, the question whether the loss is impossible to prove or not will have to be sort of demonstrated by the claimant, obviously. And in that situation, having demonstrated that this is a case of impossibility of proof of loss, the second question, that the amount claimed is a genuine pre-estimate, will also have to be demonstrated by the claimant. There are cases where it appears on first blush that courts are saying the opposite, but really those are cases, according to me, where the impossibility was obvious. And
right,
the court could ex facie draw an inference that it is impossible to conclude, it is impossible to prove reasonable compensation. So in construction design, the court said, this is not a commercial contract. This is a contract for setting up a public utility services.
Right.
It is impossible to prove the number,
right,
the quantification of the loss, and therefore I can presume that there is loss, and it is impossible, obviously, come to the next stage. The next stage is whether this is genuine pre-estimate or not. In ONGC, the court said if the contract itself says that both parties are agreeing at the time of entering into a contract that this is a genuine pre-estimate, then perhaps the initial burden does not need to be discharged by the claimant because the defendant has agreed to it. You discharge the burden, or the onus is on you now at this stage as defendant to show that it is not a genuine pre-estimate, contrary to what you have signed and stated in the contract. So the burden of proof in all cases of liquidated damages, as a first principle, will always be on the claimant, but the onus will shift depending on fact situations and depending on how much of the burden has already been discharged based on evidence placed before a court or tribunal in trial.
Interesting. And you speak of the shifting burden of proof in cases where the contract says so. So just talk a little bit about that. I thought that was very interesting.
So it's a shifting onus because I think the burden will always remain on the person, on the party that is making a claim based on this particular proposition. And I think the expression used perhaps in ONGC saw pipes was, I don't remember clearly, was burden. But I think really what overall import of the jurisprudence appears to be is that in the absence of any other evidence, this is the broadly my understanding of the law, in the absence of any other evidence during trial, it is for the claimant to demonstrate that it is impossible to prove reasonable compensation and the amount claimed as liquidated damages is a genuine pre-estimate. But there will be fact situations in which either the onus has shifted during trial on the defendant to show otherwise,
Right.
or there will be situations where the trial starts from a position where it is ex facie evident that the burden should be on the defendant.
Right.
And in ONGC saw pipes, they said where you signed as sophisticated commercial entities.
Right.
You signed a contract, you said this is a genuine pre-estimate, you even said that it is impossible to prove loss. Then why should the claimant then discharge
Exactly,
the burden
yeah.
again? It should be the defendant that has to prove otherwise.
You've been on both sides in a sense, because you're competent to deal with Indian law, with English law as well as Singaporean law. So talk to me about the difference in the treatment of liquidated damages in the UK. On what areas are they different from us?
The fundamental difference is in when it comes to layer 2, that where it is possible to prove loss, prove reasonable compensation, prove the loss that you've actually suffered. That layer literally does not exist in UK law.
Interesting. Okay.
So you straight away come to a situation where you have signed a contract, you have liquidated an amount, you've mentioned a liquidated amount, and you've quantified an amount of damages. I think that amount will then be subject to the penalty rule. If you prove that the amount, instead of being a genuine pre-estimate, is in fact penal in nature, that will sort of trigger a certain defense.
Right.
But in all other cases, the liquidated amount will be awarded, subject to sort of certain nuanced defenses in certain situations, will be awarded as damages, even if it is possible for you to prove the actual loss. Whereas in India, there is this distinction between possible to prove and impossible to prove.
Right.
And so the possible to prove situation does not exist, broadly speaking, will not exist in English law. And I think there would be greater acknowledgement of a contractual stipulation between the parties as to what compensation for a particular breach should be. There are, of course, a lot of academic views with respect to where the English law should develop. And perhaps one of the most significant developments in recent years has been the decision of the UK Supreme Court in Mark Dacey, where they recognized a distinction with a very elaborate theoretical basis, then that in certain situations, an amount that is being claimed by a party for under a contract for what appears to be a non-performance could actually be a primary obligation and not a secondary obligation. So in English law, a contract is broadly sort of understood to have a primary obligation, which is the primary contractual stipulation that you've agreed to, the breach of which will give rise to a secondary obligation, that is to compensate the party that has suffered because of your non-performance. And in English law, they recognize that certain amounts could be, as a matter of construction of a contract, could be falling rather than as secondary obligations in the category of primary obligations. And those would not be subject to the penalty rule in English law at all, because they would be closer to a pure debt claim or a contractual claim made by a party. So for example, if a contract provides for payment of annual rent for an apartment,
right,
and tenant abandons the apartment short of completing a year, and the contract has sufficient indicators which indicate that the whole annual rent was payable
like
in that situation. It may not be a lock-in, because lock-in will create an obligation.
Okay, right.
But let us say a contract says that I'm renting this apartment on an annual lease, and I will pay annual rent XYZ. And you may find a situation where the lease was abandoned even before the expiry of one calendar year. Depending on the manner in which the document or the contract is drafted, it may be possible in certain situations for the lessor to say that my claim for the balance rent for the first calendar year or the calendar year for which I was entitled to rent is in fact a debt claim, because you abandoned it. You had to just pay me annual rent in one go at the beginning of the first year,
right,
and then one go at the beginning of the second year. You abandoned it, didn't pay me rent. I'm entitled to the whole amount on account of whatever abandonment. Whereas a classic case of lock-in, where you say, I will not abandon your apartment
for the next period.
For the next period, but you do abandon, then you are in breach of a contractual obligation. So in that situation, English law has recognized a principle where the obligation then would be more compensatory in nature and not a part of your primary contractual obligation. So that distinction then leads to the next step, is that the primary obligation is not subject to penalty rule under English law, and that would be payable broadly in the nature of a claim arising under a contract as a debt.
So would it be correct to then say that the argument under Indian law would be more pre-estimate and then liquidated damages slash penalty on the other hand, and under English law it would be liquidated damages versus penalty? So if it's in the category of liquidated damages, those are likely to be granted, but if the court feels that this is in the nature of a penalty, that's unlikely to be granted.
Yes, and the third thing is that if the amount claimed is not in the nature of liquidated damages, not compensatory in nature, but a primary obligation, a conditional obligation, where you have said, so as I was talking about an annual lease, and I'm just thinking about a stipulation that says I am taking your apartment on an annual lease basis, and this annual rent will be payable irrespective of my abandonment of the apartment before the end of a calendar year. Now that is a primary obligation. You're undertaking an obligation to pay rent even if you abandon the premises. So it is not an obligation, it is not an amount payable for breach, it is an obligation to pay. So these will be matters of construction of a contract in most cases. That situation, penalty principle will not apply.
Right.
Yeah.
Okay.
So they will stand outside the regime of liquidated damages and penalties. There is no, I mean, there are one or two stray cases in India which intuitively appear to suggest something similar, but I don't see a very clear theoretical basis having evolved so far. But at some stage, the concept of a conditional primary obligation versus a secondary obligation / liquidated damages will have to be analyzed, or will end up being analyzed by courts in India. And the more interesting thing will be to lay down whether, as a matter of Indian law, a conditional primary obligation will in any manner be impacted by the jurisprudence on Section 74 at all.
Right.
Or will it be broadly similar to what is held as a matter of English law, that conditional primary obligations are unconnected with penalties and liquidated damages, and they will not be subject to those rules. I think that is that's a grey area on which, as a matter of Indian law, jurisprudence will have to develop. It will develop as a result of two things. First of all, clever lawyers will now start litigating based on already contracted documents or already drafted documents, to try to argue that the relevant contract should be constructed or read in a manner that it is closer to a conditional primary obligation as compared to a secondary obligation. But more importantly, I think lawyers who draft contracts will now would already have started drafting contracts in such a manner that in certain situations a claim for money could be presented as a claim of conditional primary obligation, not like a liquidated
With the damages clause.
Yeah.
Do you want to give away what these cases are?
I know that Justice Gautam Patel's judgment in India Bulls in in
The
Bombay,
Bombay High
High
Court.
does talk about something very similar, but does not go to the extent of
distance
providing
yeah.
providing the depth of theoretical basis that is coming out of Makdesi. But broadly speaking and intuitively, you see that the judgments, the two decisions appear to be saying the same thing.
They're sort of veering towards.
Yeah.
And the decision on Makdesi is Cavendish versus Makdesi.
That's right.
Yeah. Any last comments on where you would like to see the Indian law go?
There are two, as I said, there are two aspects on Indian law on liquidated damages that I would, given a choice, I would require, in fact, three aspects. I would require, I would expect greater clarity on as jurisprudence develops. Number one, which I just mentioned, the scope of conditional primary obligations under Indian law being unimpacted by principles of Section 74.
Right.
That is an area that we require greater clarity on. There are in international arbitration, I know that English judges have expressed a view, some of them have expressed a view that it might be impacted by Section 74, and then some of them have impacted that it will be unimpacted by Section 74. And then I know one judge who's just said that I don't even know whether conditional primary obligations and secondary obligations are conditional primary obligations and secondary obligations are recognized as a matter of Indian
law. Right.
So that is an area where I would expect greater clarity, and I think also as a matter of consistency between common law jurisdictions. The second area I think that I would expect is greater clarity on what impossibility means and what are those exceptional situations where the entire liquidated amount could be awarded as liquidated as an LD if it is proved to be a genuine pre-estimate. So I think there is a lot of there is lack of clarity around what impossibility means. And lawyers would tend to interpret situations which are not really impossible as being impossible, and then you will have lawyers trying to say that situations which are really impossible are not really impossible to prove damages situations. So I think that is an area where there should be greater clarity. And I think the third principle which I think at some stage Indian courts should consider is whether there is a good case or a good argument for reconsidering Indian jurisprudence on layer 2. Indian jurisprudence that says that where it is possible to prove loss, you must prove what reasonable compensation you are entitled to based on principles under Section 73, and the liquidated damages provision or the penalty provision is only a cap. I think there is a lot of scope for reconsideration on whether that is the right way that Indian law should develop when it comes to liquidated damages going forward, or whether we need to perhaps take a view that is closer to English law on a matter of on when it comes to liquidated damages. And we need to take that sort of considered view also in the context of the extra burden that we would be putting on our trial courts in cases where there is a liquidated damages provision, yet the breach situation is such where it is possible to prove loss. But proving loss may require 2 years, extensive evidence, and it defeats the very purpose of having a liquidated damages provision. And I think these three areas are areas where I would like to see greater clarity in Indian jurisprudence in the next few years. And I'm pretty sure that there will be.
No, I agree with you, because the market now, we can't say it's maturing. The market has matured, and contracting parties are increasingly aware of situations.
Yeah.
So thank you so much, Gaurav. It's been an enlightening conversation.
Thank you very much, Payal. It's been a pleasure. Thank you.
This concludes today's episode of Navigating Commercial Disputes. Stay tuned for more in-depth discussions on legal issues that matter most. For a more in-depth analysis, read my article dated 15th of February 2025 titled Key to Enforcing Liquidated Damages by following the link provided below.